Let's see where.
Okay, committee, it is 8 o'clock. I'll call this meeting to order. Just a couple of quick housekeeping items, committee and those here with us this morning. We are feeling a little bit of urgency this week to get some bills up and out. So I'm going to call the committee together upon adjournment tomorrow to take up the drug court bill. We'd like to work that one and get it up and out. And then, of course, we'll return to the drone trespass bill on Wednesday morning. But today we have a pretty aggressive agenda. We'd like to get through some bills and get them upstairs. So welcome. Would you please call roll, Judy? Thank you.
Senator Case?
Present.
Senator Cooper?
Here.
Senator Furphy?
Here.
Senator Schuler?
Here.
And Chairman Langdon.
Here. Judy, by the way, are we up and running? Are we streaming? Okay, welcome to those who are listening in and to everybody this morning. Good to see everyone. It's good to have Chairman Nethercott here. Good morning. First bill for our consideration is Senate File 25, District and Prosecuting Attorneys Bar License Requirement. Senator, thanks for being here to walk us through some interim work that you and your committee did.
Well, thank you, Mr. Chairman. It's certainly good to be back with the Senate Judiciary Committee. As a reminder, you are the #1 committee. So glad to see you're up and doing big work this morning on this Monday. So in front of you, you have Senate File 25, members of the Senate Judiciary Committee. What this bill does essentially is for district attorneys or county attorneys who are running for office, there is a qualification in statute that they are actually duly licensed members of the bar. And are in good standing, a pretty prudent requirement in order to be a candidate to run for these very important positions. And what this bill draft does is says that that needs to remain while they hold that office. The statute is written kind of loosely and I think unintentionally that seemed to limit it to simply during the time that they were running for office, as opposed to the time that they held the office as well. So with that, good committee members, I can simply walk through the bill, but I think it's fairly explanatory when you read it that that is actually its purpose. As you can see on page 2, lines 4 through 7, that is exactly what the bill draft says. So happy to stand for questions, Mr. Chairman.
So questions for the senator this morning. Senator Schuler.
Thank you, Mr. Chairman. Just 2 questions. And, again, not having served in the interim with this group, have there been issues in the past with some of our attorneys who maybe had some problems throughout their term? And my second question, I'll just ask it ahead of time, like county commissioners can reappoint each year, correct? So could they take care of some of these issues, or is it just better to get this in place because of statute?
Senator, go ahead.
Mr. Chairman, through you, there have been issues. And as you'll notice on page 4, line 2, or on page 2, line 4, it specifically references a district attorney. A point of note for this committee and for statutory interpretation, when you see the term county attorney in statute, that refers to both district attorneys and county attorneys. However, when you see the term district attorney, that does not necessarily include county attorneys. And so as applied to this statute, this bill draft, this is really limited to those district attorneys, primarily acknowledging, Senator Schuler, your correct interpretation that county commissioners do have the ability to terminate the employment of a county attorney if in their county, that county attorney is appointed by those commissioners. District attorneys, however, are elected. There's 2 district attorneys in the state of Wyoming, Natrona County and Laramie County. This past year and a couple of years, there has been a pretty significant issue concerning the former district attorney here in Laramie County, bringing this issue to light and needing additional statutory guidance as to how to approach an elected district attorney who may be unlicensed or suspended or other types of serious disciplinary action.
So, Senator, that begs a question that we might run into upstairs, which is what is the process if, say, the bar finds an attorney not in good standing who is serving as the district attorney? What does the process look like at that point?
For an elected district attorney who is not in good standing with the bar, what does that look like? I believe they would no longer be qualified to hold office.
So the punitive action would that come through the courts? Or I'm not familiar with all the statutes that would apply, but you can't just fire somebody who's elected, right? Would it be?
So lawyers, including district attorneys, are subject to robust rules of ethical conduct and rules of professional behavior. A complaint would need to be filed with the bar office. A prosecution by the bar prosecutor would have to commence. The attorney has the full due process, the ability to appeal in front of the Wyoming Supreme Court. The Wyoming Supreme Court also issues an ultimate decision concerning both the discipline and the sanction associated with it. At that point, when that process would take place, in the event that a district attorney was found to be ineligible to hold office, they would then be ineligible to hold office and couldn't, right? And so they would no longer be lawfully holding that office. My thoughts are, and I look at Senator Case, who may have more familiar experience with this process, is than the county party of whom that district attorney was a member of, would then appoint the next district attorney.
Thank you for that. Committee, any other questions for Senator Nethercott? Senator Case, thoughts?
It's maybe it's more in the discussion phase. I'll wait till.
Okay,
I'm gonna hold back.
Thank you. Any other comments on this bill, Senator?
No, I don't think it is complicated or that profound in its requirement that district attorneys who have immense discretion are compliant with the rules of professional conduct for lawyers.
I'd kind of like them to be qualified. Thank you, Senator. Let's go to public comment on this bill, and you can stay put, Senator, please. Anyone like to comment on Senate File 25, District and Prosecuting Attorneys? Is there anyone online who would like to weigh in on this bill? Okay. I'll close public testimony. What's your pleasure, committee? Okay, moved by Senator Cooper. That's good enough discussion. Senator Case.
Thank you, Mr. Chairman. I mean, you can kind of think about how delicate a situation this is, but these are people that are in charge with helping us to achieve justice in our society, bringing prosecutions, and if they are kind of going rogue and lose their license, which actually has happened, that's a bad thing. You can't let them just keep being there. You got to be able to do something. The other alternatives that people would have would be the commissioners. I'm not sure what the other alternative would be to get rid of a district attorney, actually. But I do point out it's interesting that they appear before the Supreme Court. And so you've also got the Supreme, so does every attorney. So it's no different. The Supreme Court could, in essence, deny them a license or remove their license as part of some bigger political game. It's possible, but that's true of every single attorney in the state of Wyoming. Only theirs would be a qualification to hold office. But I think it's a good bill.
I appreciate those comments from the chairman, who has overseen lots and lots of election law and statutes. And so thank you, Senator Case. Any other comments on the bill? Are we ready for question on the bill? Please take roll, Judy, on Senate File 25.
Senator Case?
Aye.
Senator Cooper?
Aye.
Senator Murphy?
Aye.
Senator Schuler? Aye. Senator Chairman Landon?
Aye.
Mr. Chairman, there were 5 ayes on Senate File 25.
No problem. Senator Schuler, would you consider taking this one?
Sure.
Okay.
I like these.
Yeah. Okay, the next bill for our consideration is Senate File 31, Adjacent Land Resource Data Trespass Repeal. back to you, Senator Nethercott. Thanks for being here.
Thank you, Mr. Chairman. Good senators, as you can see, this is a joint Judiciary Interim Committee sponsored bill, adjacent land resource data trespass repeal. And so what we're doing is we are repealing this particular statutory section. Just as a way of some history, both for the public and for the new members on this committee, the Joint Judiciary Committee passed out and sponsored about 4 to 5 trespass-related bills. And so you're dealing with one of those today, and I think you've dealt with another drone trespass bill. Don't let those helicopters or on the drone trespass bill send you sideways. But this bill actually
We'll try to land them in the right spot, Senator.
That's right. That's right. Shoot them out of the sky. This bill actually comes from work of the legislature back in about 2014, where there was a lot of discussion and concern over scientists and others accessing land for the purposes of gathering data, and that created a great concern with private landowners. And so the Wyoming legislature responded, and of course Senator Case was here then, and so was Chairman Landon, by creating this adjacent land resource data trespass statute, which made it against the law to do that and created a trespass. That law was challenged in court for being unconstitutional in violation of the First Amendment uniquely. And so a pretty unique legal argument that was presented by some out-of-state lawyers. Just as a word to the wise, and I always made this caution to my members of the Judiciary Committee, that they challenged the law for being unconstitutional. A federal court did find it to be unconstitutional and awarded attorney fees for over $650,000 to those out-of-state lawyers, just to demonstrate to the Wyoming legislature that this is what happens when maybe the zealousness concerning an issue results in an unconstitutional passage of law. So that money was paid for by the taxpayers and the people of Wyoming, and urge great caution, despite sometimes what appears to be the need for these issues to come forward. So the federal court determined that this law was unconstitutional, and the bill before you repeals that unconstitutional law. With that, I would stand for questions.
I think that's the first and only time that the state Senate has been wrong on something.
Indeed.
Oh, wait. Thank you, Senator. Any questions, committee, of the good chairman? Okay, thank you, Senator. If you'll stand by, we're gonna see if there's any testimony on this bill this morning. Would anyone like to testify on Senate File 31, adjacent land resource data trespass repeal? Anybody? Is there anyone online who would like to weigh in on this bill? I'm not getting much reaction. I bet maybe we're good. Do we have anyone online, Judy, who is waiting to testify on Senate File 31? Judy squared. We have 2 Judys over there.
Oh, no, excuse me.
Oh, okay, thank
No,
you.
there's nobody.
Okay, so committee, any questions of the senator? I'm going to close public testimony. What's your pleasure on this bill?
Move the bill.
Okay, moved by Senator Case. Discussion. Any discussion on this bill? Are you ready for the question? Judy, please take roll on Senate File 31.
Senator Case?
Aye.
Senator Cooper?
Aye.
Senator Burping?
Aye.
Senator Schuler? Aye. Chairman Landon?
Aye.
Mr. Chairman, there were 5 ayes on Senate
Is
File.
there anyone who would like to carry this one upstairs?
I'd be happy to.
Senator Case, thank you.
And Mr. Chairman, I do note that ever since Senator Nethercott came back to this committee, it's moved a lot faster.
I noticed, well, that's because I'm spurring the horse.
No nonsense.
I'm trying to do good in front of the good chairman, so, my golly. Okay, we're going to go to Senate File 55 Committee, Chancery Court Vacancies Extension Amendment, sponsored by the good senator. So Senator, take us away on this one.
Thank Thank you, Mr. Chairman. As you can see, the past two bills that you reviewed were a joint judiciary interim sponsored bills. This bill is an individually sponsored bill by myself, but it's not a very exciting bill, so take comfort in that. As most of you recall here, the Wyoming legislature in 2019 created the Chancery Court in Wyoming. It went operational in December of 21. And so for the past year and some change, it has been operating. We also identified when we created the Chancery Court that a judge would be appointed to fill that position pursuant to the normal processes of filling a judicial vacancy and fulfilling a role. But we recognized that for the startup of the Chancery Court, there wouldn't necessarily be the work to justify a full-time judge on that court bench. And so we've continued to kind of extend the filling of a full-time judge on the Chancery Court in exchange for district court judges volunteering their time to kind of serve as on a panel for purposes of presiding over those cases. That is working very well. At this point in time, I believe there's between 13 and 15 court cases that have been filed in the Chancery Court, so about one a month since its creation, which is pretty remarkable and a really good sign, and also consistent with other states that have created Chancery Courts for how the usage has continued to increase and exponentially with familiarity and time. The rules of the Chancery Court are different than that of district courts. And so the practitioners or the lawyers and litigants within the Chancery Court have to familiarize themselves with the different rules, as well as that court is entirely electronic in its filing system. There is no physical paper being filed in the Chancery Court. It is all electronic. And so two different and unique, I think, characteristics of the Chancery Court that will make the increasing numbers of litigants within that court be a little bit more hesitant because of the need to familiarize themselves with a different set of rules, and then the electronic filing system. But as we've seen, that continues to grow. So really a positive sign there. And again, everything is as it should be as far as usage and frequency of the Chancery Court. But for now, with fiscal conservatism in mind, we're asking to delay an official appointment of a full-time devoted judge to the Chancery Court, at least until 2025, so we can continue to evaluate the usage of that court. So that's all we're doing here, is allowing the current process that's currently taking place to continue until there's enough cases to really justify the full attention of a judge. So with that, I stand for questions, Mr. Chairman.
Thank you, Senator. Well done. I think it certainly makes sense. I look forward to a little bit of a conversation about the Chancery Courts here in a moment. But committee, any questions specific to this bill with the good senator? Senator Schuler.
Thank you, Mr. Chairman. Just one question, pretty simple. 13 to 15 cases, so I can see where the district court judges could definitely, take care of that. What would you anticipate in terms of the number of cases before we would want to have a full-time Chancery Court judge?
Mr. Chairman, through you, that's a great question, Senator Schuler. I don't know the answer to that, and certainly would want to hear some feedback from those judges who are currently serving in that role. Two things that are kind of unique to the Chancery Court. One is the types of cases that appear in front of it, which are pretty sophisticated, business-related disputes. And so that may require more consideration from a judge's time than some of the other maybe procedural or administrative type resources a district court judge is used to having to do. And then as we see the continued usage of the court, I think is also somewhat unpredictable in anticipating what those disputes are going to look like. If there's a change in the market conditions, that might result in an increased amount of litigation. So it could be that we come back to this sooner. It may be that we can come back to it later as a result of market conditions that may result in changing litigation practices.
Any follow-up? Any other questions of the senator? Okay, let's go to public. Oh, go ahead, Senator Furphy.
Thank you, Mr. Chairman. Let me ask about how much interest there is in maybe filling this position. Are judges interested in this type of court? Well, you have a feel for that? Thank you, Mr. Chairman.
Senator?
Mr. Chairman, thank you, Senator Furphy. Excellent question. I do think there's a great deal of interest in this court. As you heard in the Chief Justice of the Wyoming Supreme Court, Justice Fox, in her State of the Court speech this past week, and you might hear her mention oftentimes that district court judges are kind of the ERs of America's courtrooms. And they deal with pretty complex and intense challenges, really dealing with the human condition. So they deal with juvenile cases for abuse and neglect.
Yeah.
They deal with homicides. They deal with mentally ill and substance abuse. And that can get pretty taxing just from an emotional perspective, and then also from the inability of legal resources to really address some of those needs or concerns. And so the Chancery Court doesn't deal with any of those issues and is really those civil disputes that may lend themselves to some of the more academic pursuits of some of the members of the judicial branch, or serve as a reprieve, I think, from some of those daily challenges that our district court judges experience as a result of the challenges that we see in society. So there's a great deal of interest.
Senator Case?
Would it be possible to tag on a little bit?
Absolutely. Absolutely.
I think one thing that's important is it helps us to develop our body of law with respect to the corporate and business world. We have great laws on the books, absolutely fabulous, but Delaware is the gold standard. And corporations and people prefer Delaware from the sense that there's this body of business law and interpretation that is very, very robust. We're going to get there, but we're way behind them. And having this specialized court to address this, I think, is really important in our economic future, and to have really a solid business environment. And it helps also to maybe offset a little bit the taint that we might have because of our easy incorporation and our anonymity. So, which it's all in evolution right now. But I think it's a really important thing. It's a piece that's been missing.
You alluded, Senator, to those district courts, and you and your committee did great work over the last couple of years to get us caught up a little bit there. And I think that will certainly help as they try to peel off and fill the vacancy over there in the Chancery Court, will it not?
Mr. Chairman, I do believe it will.
Yeah, that was good work. Okay, let's go to any public comment on this bill? Any public comment on Senate File 55, the Chancery Court vacancy bill? Anybody online? Okay. What's your pleasure on this bill, committee? Moved by Furphy. And discussion. Anything else? Okay. Let's take roll, Judy, on Senate File 55, Chancery Court Vacancies Extension Amendment.
Senator Case.
Aye.
Senator Cooper.
Aye.
Senator Furphy.
Aye.
Senator Schuler. Aye. Chairman Landon.
Aye.
Mr. Chairman, there were 5 ayes on Senate File 55.
Senator will be right behind you up there on the floor.
Thank you, Mr. Chairman.
I'm going to see if we can't text Senator Barlow, because his bill is going to get up. We had listed that if time permits. Do you by any chance, Judy, have his phone number? I do. If you don't, I'm not sure that he would expect to be up quite this quickly.
Mr. Chairman, I'll let him know.
Yeah, thank you very much, Senator.
And with that, do you want to go to Senate File 69, Mr. Chairman?
We sure do. And Senator, I'm going to let you do that as soon as you get that text done.
Done.
And because I have full faith that we're going to get to Senator Barlow's bill this morning with you taking care of 69. So take it away, Senator. Thanks for being here again.
Thank you, Mr. Chairman. I appreciate the committee's time this morning. Good Senator, Senate File 69, electronic records retention. And so what this bill does really is easily explained if we look on page 1, lines 1 through 3. This is an act relating to the courts, providing for the digitizing and retention of court records and striking obsolete language. So essentially what we're doing, committee members, is changing the court's record retention policy from microfilming, from microfiche, to scanning and digitizing, and then in continuing with the records policies by rules of the Supreme Court, which is currently in place, and just really updating our record systems to allow for a modern and accessible record system, recognizing that microfilming and microfiche and physical files probably is not a prudent plan for the future. Happy to stand for questions, Mr. Chairman.
Senator, you brought something that honestly, I have not heard that word in a while. Microfiche. Yeah, how about that, huh?
Librarians still like it, archivists.
Yeah, there you go. Senator, thank you. Any questions or discussion, committee, with the senator on this one? Okay, let's go to some public comment. Any public comment on Senate File 69, the electronic records retention bill? Is there anyone in the room? Anyone online? Nobody online. Committee, what is your pleasure on this bill?
Move the bill.
Okay, moved by Senator Schuler. Discussion. Any further discussion with the chairman of the interim committee? Okay. Judy, please take roll on Senate File 69.
Senator Case.
Aye.
Senator Cooper.
Aye.
Senator Turpie.
Aye.
Senator Schuler.
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there were 5 ayes on Senate File 69.
Okay.
Mr. Chairman, I am a co-sponsor of Senate File 99. I would be happy to present Senator Barlow's bill for him if you would like, or I can.
Senator, I think that is a cherry idea. Let's move on then to Senate File 99, witnessing of wills, remote methods. Take it away, Senator. Thank you.
Thank you, Mr. Chairman. I know that Senator Barlow had this issue presented to him during the pandemic. As we recall, during the pandemic, there were restrictions on access to medical facilities for visitors and witnesses for public health emergencies. And that became a challenge because oftentimes as practitioners, as a lawyer, I know that people oftentimes don't do their estate planning timely. And it's not until they're faced with a circumstance that requires them to expedite that planning, do they actually get that done? And oftentimes that means that they're in a hospital or some other type of medical facility. And during the pandemic, that became very challenged and really impossible as an inability to have witnesses be present as required by Wyoming law for a will to be lawful and to be effectuated. Under Wyoming law, there is a requirement that 2 witnesses witness a will as it's being signed by the testator or the person signing the will. And of course, as you all recall, that became very challenged. And so Senator Barlow's bill here provides the option for remote witnessing of wills, and that's found on page 2, lines 14 through 21. And I think it's important to recognize that there are some limitations about this. And so if we read that subparagraph, it says witnesses to a will may appear in person or by the use of audio-video communication technology due to public health restrictions or other exigent circumstances, provided that the witnesses can see and hear the testator in real time, have the opportunity to judge the competency of the testator, have the ability to securely sign the will electronically, and can determine that the testator is freely and voluntarily signing and executing the will. And those are typical requirements of a witness who would be present with a testator in the room. And a testator is the person, again, who is signing that will. Some background information on this, of course, is that a couple years ago, we also passed remote online notarization of documents. the Wyoming legislature did afford that, recognizing the need to modernize our statutes on that front. And so a notary public can notarize documents remotely as well, as long as that is happening in real time as well. So I think that's a very important protection associated with both of these concepts of remote witnessing or even notarization of documents, very important documents that are used in legal proceedings and to do very significant things with people's property. With that, Mr. Chairman, I would stand for questions.
Any questions? Senator Case.
The only question I have is about the standard of, mentions health emergency or
Exigent circumstance. What is that in practice, and do we really need that? Couldn't it be any circumstance? I mean, what's the standard here? Thank you, Mr. Chairman.
Senator?
Mr. Chairman, thank you. I think that's a great question. I think Senator Barlow put this in kind of as a safeguard out of concern over the change of this practice. It is a significant change, right? And so there's concerns when someone signs a will of undue influence, of capacity and competency issues about whether or not they understand the document that they're signing, whether or not they're being unduly influenced. And so those concerns are very real, which is the requirement to have two witnesses in a room. Excuse me, Mr. Chairman. And so by going to this remote capability, there might be additional challenges associated with that. And so whether that becomes the custom and norm, I think caution and maybe some more discretion was considered associated with that. Should that be a policy? Is it necessary? Certainly a question for the legislature to determine, and certainly this committee as well. I'm not sure it's a requirement, but caution, I think, is appropriate.
So, Senator, as a follow-up to that, there's language in the bill that that speaks to the competency. Do you have any concerns on that front, that a witness would really be able to make that determination over a Zoom call?
Mr. Chairman, the answer is yes, they could be able to make that determination over a Zoom call, just as easily as they could by sitting in the room. I mean, determining competency can be a challenge. There's different types of competency, of course, for people to consider. Generally, a requirement in this case is whether or not the person knows what assets they have and what they want to do with them is usually the requirement.
Yeah, very good point. I mean, I'm sure that's a little bit challenging at times, even if you're in the room. So, yeah. Okay, the committee, any other questions of the senator on this one? Thanks for pinch hitting on this one. Senator Case.
Well, Mr. Chairman, wills get challenged all the time. Yeah, it's fodder for, somebody's always mad when somebody dies and it doesn't work out like they thought. So I'm wondering does this mean that the witnessing of the will could be challenged if the circumstances were not exigent? I never use that word, but exigent. If the circumstances indeed were something a little less than exigent, we're going to argue about that in court. And would that be a basis for challenging a will?
Mr. Chairman, yes, I believe it would. Senator Case.
So, Senator, I see where you're going with that. I mean, I'm not sure there's a way to tighten that all the way up. There's always going to be room for challenges on wills, but
Well,
the exigent piece, I see what you mean.
well, and just think of the circumstances. They're trying to get a will done. The attorney and the family and everybody, and who's going to be the witness? And we got one witness here. Let's get another one on Zoom. And, but the truth is, when you step back, you go, did we really have to get the one on Zoom? Would there have been any other way to do it? Could we have thought about this earlier? I'm just worried about that standard. But the trouble is, it says health restrictions in the same sentence. And I'd probably just say, this allows both witnesses to appear too, as opposed to just one. But I'm not sure I would have any restriction, if you really want to get down to it.
So,
We don't have to be in person to pass bills now. And why should you have to be in person to witness a will?
so Senator, you touched on, and so did Senator Nethercott, that these are circumstances, we were in them not that long ago in my family. You know, your dad is in hospice care, or your mom, family member, really difficult circumstances. And gosh, you know, there's a big piece of me that believes this is really appropriate. I mean, we really, I think, need to provide this opportunity, but I'm sure it could potentially create something that someone would have heartburn over. The two areas that we kind of talked about this morning. Senator Nethercott, any thoughts on that front?
Mr. Chairman, I think Senator Case probably is right in his concerns, and don't know that the restrictions associated with remote witnessing are necessary and likely will cause more harm than good.
So it might be one of those laws, Senator, that you get out there and get on the books, see what you run into, and we might be visiting a couple of years from now to tighten something up or do something different.
Well, Mr. Chairman, I think it wouldn't be improper to strike essentially line 16. Fix it now.
And Mr. Chairman, I'd love to do that. Without that bill sponsor here.
Yeah.
I might bring a floor amendment, but I actually think we probably ought to go the other way on this and not have it be tied to, don't allow for mischief here.
Thanks for keeping decorum on the desk here with us, Senator. I think that's a really great approach. I think we could certainly go upstairs and share with the sponsor the conversation that we had, and we've got some good heads who could maybe weigh in on that front. Chances are that the sponsor will agree. So, Senator, any final thoughts on this bill? Thank you for pinch hitting on it.
No, absolutely, Mr. Chairman, and thank you for the opportunity to make sure the bill was heard. I think that's the policy question for you to consider is whether or not you want to allow wills to become lawful via online witnesses, remote witnesses. That's the policy question. And I think our world requires us moving in that direction.
Yeah, good thoughts. And I can certainly understand why the sponsor wanted to carve out a niche, get us started. But yeah, good conversation for up on the floor. Let's go to public comment. Is there anyone online, Judy, waiting to comment on this bill at all? Would anyone in the room like to oh yeah, I guess we have no one in the room. So I'll close public comment. Committee, what's your pleasure on this bill?
Move the bill.
Moved by Cooper. Discussion, any further discussion? Senator Furphy.
Thank you, Mr. Chairman. I would like to propose an amendment to eliminate on page 2, line 15, the last two words, due to, and then eliminate completely line 16. So it would read communications technology provided that the witness can see and hear. So that's my motion.
Okay. Discussion.
I'm super good with that. But I wonder, how will Senator Barlow feel about that, you know? And we could do it as a floor amendment, or,
Maybe given the fact that the sponsor could not be here. Senator Nethercott did a great job on the bill, but, you know, that would be
Mr. Chairman,
my only caution. Senator Nethercott, go ahead.
you do what's right to make the law the best.
woohoo,
Oh,
it's that tough chairman I love.
There you go. I like that.
Second.
By golly, we can always put it back in upstairs too.
Yeah, we could.
That's the way I
It's
look
gonna
at
be a
it.
standing committee amendment, and we can
Oh.
always, you know,
That's absolutely true. So, all in favor of Senator Furphy's motion, say aye.
Aye.
Any opposed? No. That motion carries. We're back on the bill. Is there anything, Judy, did you get that? Line 15, due to, and then all of 16,
Yes.
striking that language. Okay. Back on the bill. Anything else, committee? Ready for the question? Judy, please take roll on Senate File 99, witnessing of wills.
Senator Chase,
Aye.
Senator Cooper,
Aye.
Senator Ruby,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there were 5 ayes on the amended Senate File 99.
Okay, that bill, and I failed to step in on all these bills to remind the committee that they have passed. Each one of them were 5-0, and we'll take them upstairs and see what happens upstairs. Just as a reminder, committee, I'll work with Judy to set up a meeting upon adjournment tomorrow. To take, my thought is to take up the drug court bill. That's a major policy decision for the legislature to transfer those drug courts over to the judiciary branch. So I want to give it good time, and maybe all by itself. We may stick another bill with
Did
it.
she steal your bills?
But my intention would be not to spend well into the night. We'll just knock out a bill or two. Mr. Vice Chairman, does that sound okay?
That works for me, Mr. Chairman. Thank you.
Okay, all righty. We'll work on that, Judy, a little bit later. And
I do have a comment.
yeah, Senator Cooper.
Thank you, Mr. Chairman. Senator Nethercott has left, but I'd like to publicly thank her for the work she did on this type of bills. These are not terribly exciting bills, but they're important. They have to be done. And somebody's got to do them. And I'd like to just publicly thank her for the work she did on these very exciting bills.
I will definitely second that.
Let's do something on the floor.
Thank you. Yeah.
Let's say something.
Yeah, I think that's very appropriate. And that was also in the back of my mind, you guys. The Judiciary Committee's done a lot of great work over the last 4 years. All of the justice reform and all of this trespass legislation, and Senator Cooper was alongside. Great work. Good job. Is there anything else for the good of the cause, committee? Senator Cooper.
I did see a little bit of concern on the good senator's face when we discussed our meeting tomorrow night. We'll have to suggest that we talk to her a little bit about timing. I'm sure that she'll be tied up in appropriations. And see how she'd like to handle that.
I'll sure work with her. Yeah, thank you, Senator. Plan to do that. I just want to make sure we give adequate time and attention to that drug court bill. You guys did some great work on that, so